uh, ready to get going on today's Get Smart class, and today's the exciting topic of deadlines. And so we do have a lot of issues with deadlines. I know you guys do. And given what you do and the nature of that contract, and that's what we're going to talk about today. There are so many deadlines in there and things to worry and obsess about. For what it's worth, I feel your pain. I mean, as a lawyer, we've got our own raft of deadlines, statute of limitations, and all of those pleading deadlines, contract deadlines and stuff we deal with. And, when you're really, really busy, like everyone is these days, deadlines can wear you out. But so that's what I wanted to talk about today. Kind of go over how we calculate the deadlines, talk about some of the more important ones in the contract, and then sort of invite the group and Donna and Liz and Tanya and whomever we've got, or you guys, to chat about it a bit. So in terms of, so what we're looking for in this context in the contract is, you do something within 3 days or within 10 days or 7 days or by X date. But when you're calculating days, and all three contracts do it pretty much the same way. I've cut and pasted the language from the three contracts we're using, the RAIN, CVR, and VR. And they all more or less do it the same way. So for example, in RAIN, and you guys can see it here on the screen, the term day shall be deemed to mean any day of the week, Monday through Sunday, regardless of any holidays. And, as a rule of thumb, no matter what you're doing, I would count every day Monday, just like this is defined. For deposits where we've got this VREB, a Virginia statutory requirement that the deposit be made within 5 days, that's banking days. So that's really I think, I could be wrong about this, but in all the contracts, I think that's where the only place where we really get into the concept of banking days and holidays and that sort of thing. And for the deposit rules, and that's a big deadline, and I hope you guys know that. And for those of you who are new and rookies and just getting started, unfortunately, if you don't get that deposit in and properly, then it's an automatic board violation, and we've got to report it. We're in trouble if we don't report it. So that's pretty much automatic, and that's one of the more important deadlines, obviously, for lots of reasons. But in any event, so that's really where you're going to see banking days. And the RAIN contract goes on to define those business banking days, Monday through Friday, except federal holidays. RAIN goes on to say the day starts at 12 a.m. and ends at 11:59 p.m. Just as an aside, I'm not really sure there is such a thing as 12 a.m. It's either noon or midnight, but in any event, I digress. And then, it goes on and it adds this other language, which frankly is just confusing to me anyways. But, fundamentally, it's beginning at midnight today, ending at 1 minute before midnight. That's your periods of time on the clock, so to speak, for when the day begins and ends. And days means Monday, through Sunday, all of them. CVR is a lot simpler, a lot more straightforward, and I think sufficient. Day means a calendar day. That's Monday through Sunday. For purposes of computing time periods, first day is the day following the commencement, and I'm going to get to an example here in a second. And VR follows the same sort of course. Days means calendar days, Monday through Sunday. First day following the date of ratification or delivery of the notice that triggers a time period. Well, it's all pretty much saying the same thing. And then VR figures they need to add the 11:59 p.m. So you can see between the three, well, CVR is pretty straightforward, doesn't see any need to give time periods. And for what it's worth, the Virginia Supreme Court on our time periods and the Virginia General Assembly doesn't feel that's necessary either. Rain and VR, Rain's gonna tell us what kind of clock we got to use. VR is sort of a hybrid between the two of them. But in any event, they all work the same way. So let's suppose that you had to do something, in the languages within 3 days of the day of ratification. And we're going to say the date of ratification was June 1st. So within 3 days, your next day, June 2nd, that's day one. June 3 is day two. June 4 is day three. So within 3 days means by 11:59 p.m. On June 4th. Does that make sense? Everybody with me on that? Okay. Just to talk about some of the common deadlines, you just go through the contract. One that we don't talk about much is the deadline and the offer. It seems like the market's, so rapid that you're finding something out pretty quick, and that's not an issue. But, so a buyer makes an offer. Well, how long is that offer good for? And in that context, what we really mean is how, at what point does the seller have the right to just accept it? Is it a couple of days? Is it a month? Is it 90 days? Well, the CVR contract and the VR contract, and those of you that are using those, you recognize there's a block, a paragraph near the end, really, I think it's almost both cases right above the signatures, where you say how long the offer is good for. And so that's sort of a deadline of sorts. Donna, correct me if I'm wrong. I know the Rain contract didn't used to have it, and I don't think the Rain contract still
There's no deadline. There's no
Yeah.
deadline in the Rain contract.
So I want you to think about that. If you're writing an offer for your buyer, you don't hear back. Maybe you talk about it, but you just don't hear back. You guys need to sort of bear in mind that if you're going to move on, you need to make sure you affirmatively withdraw or revoke that offer. Otherwise, you're liable to have a new contract going on a different house, and all of a sudden the seller comes back and accepts your offer because you never withdrew or revoked it, and the seller never countered it or rejected it. So, if on a Rain contract, you write the offer and the seller counters it, okay, well, they've rejected your offer, so you don't have to worry about that anymore. So if they counter or they just flat out reject it, then that's fine. You don't have to worry about it. But I have seen situations where those things are lingering out there, or a seller makes a counter. It works the other way. So if the seller counters the buyer's offer, so that seller counter is just sitting out there. It has no deadline, no time period. Buyer could think about it a week. The seller's got other people interested, and then all of a sudden, that other buyer comes in a week later and accepts the counter. So you got to be careful about that with the Rain contract. It's not, the way the CVR and VR contracts are written. I just don't think it's.
Oh, yeah, I can hear it. Can you hear it?
Really an issue there. So, I don't think you need to particularly worry about that. The only thing I have seen that comes up on the VR, CVR contracts, because they do have a deadline, is, so people just ignore it all the time. And the contracts get signed after the contract by its own terms says it's not any good anymore, right? So what do? Do you have a contract? Somebody tell me in the chat room if you got a contract. Let me make sure you understand. So buyer writes an offer, and let's just say it expires 3 o'clock on, it was a couple of days ago, and it expires 3 o'clock today, which is what, the 6th, I think. And on the 7th, after some, text back and forth between the agents, the seller goes ahead and accepts it. So it's been accepted after the deadline imposed by the buyer. So I get asked this fairly frequently: do you have a contract? I can't wait till we have live training and I can pick on you guys and make you answer it, but I think that's kind of hard under these circumstances. I think you have a contract. I'm pretty confident the Virginia Supreme Court would rule that the parties decided to sort of trump that deadline by signing and accepting it. Now, you could have a situation where the seller, it's not done by consent and the buyer saying, oh, no, you signed after the deadline. Well, yeah, under those circumstances, you're not going to have a contract. But where the parties do agree and move forward, the buyer's not going to be heard to say 2 weeks into the deal, oh, well, you signed this after the deadline, I'm out of here, when all along they've pretended and communicated as though they had a contract. So I'm not really worried about that circumstance. There are a few pre-contract sort of deadlines that are worth mentioning. You guys take care of this. I never see it come up anymore. So the Residential Property Disclosure Act form, and all the things, the defective drywall, AQs, all of those things that are required to be disclosed to the prospective purchaser prior to the prospective purchaser's offer. That's a deadline of sorts, but that's worked out pretty well now, I think, in the MLS and how you guys handle it. A pretty big deadline is the Property Owners Association Act. From a seller's standpoint, there's no deadline exactly, but you need to do it. Until you do it, the buyer hasn't out at any time. It's your submission or your seller submission that triggers the deadline on the buyer, of course, the 3-day right to cancel. So that's an important deadline that comes up. I know sometimes your clients push you right to the edge of the 3 days and you're sort of freaking out and, oh my God, it's in hours or the next day or something like that. And you're worried about calculating days. So I see that one come up a fair amount. You got to make sure you're on top of it, make sure your client's aware of it. And then it's going to be up to your client. If they blow the deadline, that's on them. I think as a good agent, you're reminding them, keeping, on track. And I know you guys are doing that. There are any number of inspection and repair deadlines. Home inspection, of course, triggers all sorts of deadlines, has to be at a certain time. You have to, promptly or perhaps within a certain time, request your repairs. The negotiation period, all of those deadlines that go along with the home inspection. I think all of these are pretty straightforward. It's just in that they're in the contract. We've talked about how you calculate the days, and many of them just say what the deadline is by, given date. But in terms of trying to work through those, I don't hear a lot of deadline questions on those kinds of things. As far as the repairs, we talk about it fairly frequently, and I think we've had another class where, there are deadlines on repairs. First of all, many of the provisions and addenda in the contracts themselves say that, the work's to be done X days before settlement, provide receipts. And that's a deadline of sorts. Now, it may not be a deadline like the, cancel within 3 days of getting the POA packet. It's not exactly that kind of deadline, but it can be, and your client can be in breach. And for example, we've talked about this a number of times under particularly the RAIN contract, but there's language in the CVR contract as well that, if you don't have the repairs done in a timely fashion, the other side, in this case, that would be the buyer, has a right to terminate the contract. So that's kind of a hard deadline. And it's, a deadline's one thing where you sort of have some control over it, at least it's maybe just you and your client. But of course, the problem with the repairs is that it's not, you and your client, you start it, you hire the folks to do the work. But then you're at the mercy of them and when they do it and when they get the stuff to you. Meanwhile, you may have this hard deadline, in the back. I think all you can do is, uh, order early, order often, and then just keep on top of it. That's realistically, I think, all you can do on those. The next one, financing, of course, and that's sort of linked to appraisal. All three of the contracts to varying degrees of specificity and with a few differences that aren't that important for, this class. The buyer has to do something with it, make the application, pay for stuff. It's got to be done within a certain period of time, a number of days, 7, 5, 10. You have to get the commitment, in the VR contract, you got to get a commitment by a given date. So the way the modern contracts, those three are typically written, is that, again, you're triggering a right to terminate in the other party if they're not done on time. On those, I don't think there's any significant legal discussion, just noting that they're there and the impact of missing them. Closing date, boy, we have lots of fights about this. We've talked about it a little bit in a different class. I mean, the closing date is a deadline. And quite frankly, I think to the parties, it's just the most important deadline of all. I mean, you guys know this, they hire movers, they make plans, they got babysitters, just all of that kind of stuff. Anticipation of a particular closing date specified in the contract. And while, other than maybe the rain contract in a roundabout way, time isn't of the essence on that date, whereas the parties view it as a hard deadline and of the essence. It just doesn't, expectations don't mirror the language of the contract and Virginia law, frankly, in terms of that being the kind of deadline that we all really treat it to be. So again, I think that we consider that a deadline, we work towards it, but it may not be the same sort of deadline that some of these other items are. Can't necessarily, other than the rain contract, you can't necessarily terminate the contract or walk away from the deal or demand damages and those kinds of things. Deposit, we mentioned earlier. And again, for the rookies, the reason we hammer that, I'm sure, in your rookie classes, you get it at some point as well. But a number of years ago, maybe now 10, 12 years ago, something in that time frame, the Virginia Real Estate Board, DPOR, Department of Professional and Occupational Regulation, they had a lot of problems with escrows and, not being tracked properly, not getting deposited on time. And so they really came down in a very hard way about that. So now we have these very specific regs about how quickly that money has to be deposited, how it's held, how it's accounted for. And VREB has made it very, very clear that if you don't get that done, it's a board violation. Your principal broker is obligated to report you. Otherwise, the principal broker is going to get charged, and we just don't have any discretion. And it's easy to happen. Making a copy of the deposit check and it's left on the copier, and you're busy, and things happen. We've tried to make that from a company standpoint as easy as possible with the electronic deposits, and hopefully that's helped a lot. Donna, do we have any sense of how frequently that's used?
I don't have a sense percentage wise, but I think we're using it a fair amount if the buyer's bank participates.
Right. Title, I don't know that that's a deadline exactly. There are some deadlines associated with that, particularly in the VR contract. From our standpoint at the title company, we're wanting to order it as quickly as possible. But, for example, in the VR contract, the seller's got 60 days after notice of the title defect. And so we view and treat that as a little bit as a deadline as well. So as I went through the contracts and looked at, just going kind of clause by clause and then somewhat from memory, in terms of a grouping, I'm certainly not going to say those are the exclusive deadlines that the contract creates, but generic, in sort of a categorical way, I think that pretty much covers it. But, for example, financing, like I mentioned, there's probably 6 deadlines within the general financing clauses regarding appraisal and credit report and application and commitment and all of those kinds of things. So there's a heck of a lot of deadlines in your typical residential real estate transaction. And so how do you manage them? Donna, do you have any suggestions? I'm not sure in terms of checklists that the company has, or Donna's left. Liz, you there? Tanya? Sandra? I'm deserted by the managers, not telling you.
Brian,
Yeah,
Brian, this is Peggy.
go for it.
Workflows will help you keep on track, because if you fill out your workflows, it gives you a to-do reminder email as it's due until you complete it.
There you go. I knew the company had something. Thank you, Peggy. I will just tell you, and Brooke's confirming what Peggy just said, so it's workflows. And then how you guys do it, other than that, that sounds like a great solution, and it'll help you keep track of things. So what I do is obviously different than you guys, but it's similar. And as I mentioned, in deadlines, I'm just a checklist kind of guy, and make lists. I have paper lists. I use my email inbox as a to-do list. I then create, so you guys, I think, y'all are using your phones more, I think, and I could be wrong, and I guess it depends on the individual agent, but y'all are using your phones more than your computer for email, and on your phone it's text. But so I really try very hard not to work with text. So I'm an email guy, and for me, that just gives me a lot of opportunity to be organized and to have my to-do list and deadlines. And I just throw it out there. So the way, I do it, again, I still make manual list of things to do, usually in the morning, to just sort of clear my head, prioritize things and come up with a daily game plan. But so I use Outlook email, and my inbox is sort of a first level to-do list. I don't take something out of my inbox that I need to do until I've done it. And then once I've done it, I get it out of my inbox. And Outlook makes it really easy. You can drag and drop an email to the task. You just drag and drop it, and then the calendar pops up, and you select the day for when you need that to be done. And I can type some notes in it, and I can drop files in it, so that when I pull it back up, I've got everything I need. And so for me, that's a second level sort of deadline, make sure I don't miss something. And then, of course, for me, my third level is when I'm just scared to death I'm going to miss a deadline. Well, actually, I have 4 levels. But so my next level above the task is I'll actually put it on my calendar, like an appointment, and say, Brian, statute of limitations runs tomorrow on such and such a case. You'll lose your license if you don't work on it today. I'm being facetious, but in any event, I really prioritize it that way. And then, so if you can't tell, I'm a little OCD about deadlines. My 4th level is, I don't know if you guys know this, but in Outlook, so I send emails to myself all the time as reminders. Some will occur to me, whether I'm on my phone or I've got my iPad. I'll send a quick email to myself so that it's in my inbox, which is kind of my first level to-do list. But when I'm really getting OCD about something, you can do an email, and then you can delay delivery on it. So if I think it's going to clutter something up, I'll create the email reminding myself to do something. You go to options in Outlook, you click on delay delivery, and then you can set the date and time that that email will be sent. It'll stay in your outbox until that happens. And then so, if I know I need to be reminded that I've got to get ready for a Get Smart class and I got to get on that the next morning because I got a full day otherwise, I'll send an email to myself for delayed delivery that goes to me at 6 a.m. in the morning, which is when I'm usually first up checking my email. So that's Brian's Get Smart, Get Crazy, Get OCD. That's how I handle deadlines. If I had a workflows thing, I probably wouldn't need to do all of that. So, so I see Brooke apparently uses delay delivery in Outlook as well. Good for you, Brooke. I thought I was probably the only crazy person in the world that sent delayed delivery emails to myself. That's really all I have. Do you guys have any questions or anything?
I had a question that just came up and talked it over with Liz, but what about transfer of warranties, like on a contract? For example, I had a contract where the windows was under a lifetime warranty that went with the house and it needed to be transferred. And we included that like on the PICRA, but how do you
actually do it?
No, they didn't.
Well, so that's a great question, Tiffany. A lot of those kind of warranties automatically transfer with a transfer of ownership. Now, the question would be, well, you say a lot of them, do they all? No, they all don't. Well, how do you know which ones do and which ones don't? You got to actually look at the warranty to see if that's the case. And sometimes, of course, it's hard to find that original warranty. But if you can find that, or, so the seller and getting the house ready had new windows put in and advertise markets that, the seller probably ought to still have that warranty information, and you can ask for it and then check to see if it automatically transfers with ownership. If you didn't know, or you couldn't find out that way, then really what you would do is there'd be a document, assigning, and we'd probably do it as an assignment where the seller transfers any and all right and title and interest in, and, to the manufacturer's window warranties and, sign and date it and provide it to the buyer at closing. We, maybe 1 out of 1,000 closings, I've been asked to do something like that. So it's pretty rare. And I think we're assuming that, if they are transferable, the likelihood is they automatically transfer. If it's something really important and there's a great deal of concern about it, what I would say is let's drill down, see if we can get a copy of the warranty and verify that it automatically transfers. And if we can't, and it's important, then we'll try and do a form to get it, at closing. Because some manufacturers' warranties are not transferable, and it doesn't matter what we say. I mean, if they're not transferable, they're not transferable. So does that answer your question, Tiffany?
It does. That was just about windows, but it just made me wonder, like, what would happen? Because I've seen that before too, like brand new roof still under warranty, or, how do you as the buyer's agent verify, those warranties? So I just kind of had a question like about that. I mean, I can, and the seller's agent had the nerve to tell me they had 30 days after closing to do it. And Liz was like, no, they don't.
Yeah, no.
There's
No,
such thing.
depending on the language in the contract and what you've asked for and the circumstances, you push for it. It needs to be done prior to closing. If something comes up on a particular situation, reach out to Liz or get me involved, and we'll push back a little bit. So.
Yeah, now that you said most of them, and I thought, Window World is a big company, but I thought, what if you had like a roofing company that was maybe like local and they had a warranty on the roof, but how would you go about ensuring your client got the warranty? But if we're assuming that stays with the house, so to speak, then automatically transfers, then that
Well,
is.
yeah, again, I don't want to say that you know, that you necessarily can always assume that. I think we kind of do, but you know, it may not be the greatest practice in the world to make the assumption. I think that's
Okay.
part of, you know, in the contract where work's being done, asking for a copy of the warranty and receipt,
Okay.
the work's been done, and then you take a look at the language and make sure it's going to cover your buyer.
Okay.
Anybody else? All right. Yeah, Kenny, did you have something?
Actually, yes. Brian, there's new language. I say new, it's been in the contract for probably about 6 months now, or longer, but back to the EMD deposits where we typically have 5 days. There's new language in there that says that we as the buyer's agent have received it or will receive it within 2 days, and you check either option. I've seen some listing agents determine that to mean that we are supposed to deposit it within 2 days. Do we have any idea of, is it 5 + 2 to have 7 days to deposit an EMD if you check off?
It's going to be within receipt. You know, 5 days within receipt of the deposit. So if the contract's providing that the buyer has, say, 2 days to get it to you, and you're going, and you know, you, Liz Moore and Associates, is going to be holding it, you're going to have 5 days to deposit it. I mean, I guess I'd have to see what it is and how it's written, that they think that it's interpreted differently, Kenny, but I just don't. I'm confident they're going to be wrong about that. So I pulled up on the screen, you know, the current, I take it you're referring to a rain contract?
Yes.
Yeah, so I've pulled that up on the screen. I don't see that language held by, is it in a different part? Oh, down here.
There it is. Yep.
Yeah, so what you're talking, yeah, hold on a second. I got it. So it's this language here. You know, if this block is checked, it's saying we'll pay the deposit to the escrow agent within 2 days. But that doesn't change the 5-day rule, Kenny. It doesn't.
The ratification, it starts on the ratification.
Yep. Okay, that helps. I've just seen some agents say it needs to be deposited with 2 days because it's checked off. So.
No, I mean,
Okay.
That's clearly not what it's referring to. And there's language. So if you go on down to 5, you know, this is the end of the 5th business banking day following escrow agent's receipt of the deposit. See that? That way, I'm trying to highlight it, but it keeps flagging. But right here, 5 business banking days following escrow agent's receipt of the deposit. So if up here you say 2 days after ratification, the buyer has 2 days after ratification to get it to the escrow agent, then the paragraph 5 ties into that to clearly mean 5 days after that point where you get it. So that would be up to 7 days, but not necessarily so. So if you got it, if it said within 2 days, you got it on day 1, okay, you got to get it deposited by day 6. You don't get that extra day. It's from the date of receipt, 5 days. All right. Okay. All right. Well, guys, thanks for joining in. I appreciate it. And I'll see you next week. Have a great day.
Thanks, Brian.
Yeah.